Hey everyone, Amy Odom here from the court team at Chisholm and Kilpatrick. And today I have an exciting story to share with you about a case that we've recently worked on at the U.S. Court of Appeals for Veterans Claims. This Vietnam veteran had been awarded total disability based on individual unemployability in the early 1990s because the VA had determined at that time that the veteran's service-connected disabilities rendered him unable to work, essentially. But then in 2006, the VA determined that the veteran was no longer unable to work because of his service-connected disabilities. They allegedly had found some information that indicated that the veteran was in fact working and receiving an income, and therefore they proposed to terminate the TDIU benefits. So that would mean that he would go from being rated 100% based on an inability to work back down to a lower scheduler rating, which would mean that his monthly checks would be a little bit less than they were. But not only did they decide that he was no longer unable to work in 2006, they also decided that he had been able to work since 1996. So they decided to terminate the TDIU effective 1996, so like 10 years prior. And that created a debt because now they were also saying, we paid you at the 100% level since 1996 and we shouldn't have been. So now you owe us all the money that we paid you that we shouldn't have been. Luckily and thankfully, this veteran filed a notice of disagreement with the regional office's decision and appealed the termination of the TDIU. And it got all the way up to the board several times. And the board kept remanding it because, lo and behold, whatever evidence the regional office had relied on in 2006 to find that the veteran had actually been working and receiving an income was no longer in the claims file. Nobody knows what happened to it, but we do know that it was not in the claims file when it got up to the board and was never actually recovered. So fast forward 14 years later, so in 2006 is when the VA terminated the benefit, and now we're in November 2020, and the veteran comes to us with a final board decision. The board decision says, yes, the regional office was correct to terminate TDIU benefits effective 1996. So, to take back the 10 years of payment that they had been giving him. And the board said, it's true that the evidence that the regional office relied on to find that he was working and making a substantially gainful income is no longer in the claims file. And we don't really know what happened to it, but if the regional office said it was there and said that he was working and getting a substantially gainful income, then we believe him. And so the Board of Veterans Appeals decided the termination of TDIU, 10 years retroactive, was right. So obviously we took that case to court. And in this particular, usually when we have a complicated issue or, sometimes when there's a lot of money at stake, we end up having to draft briefs and get a judge to decide the case, but not this one. We had a pre-briefing conference with the VA attorney. We laid out the fact that, number one, it's totally illegal for VA to retroactively terminate TDIU. Because remember, not only did they say in 2006, we're going to terminate TDIU, they said we're going to terminate it effective 1996, so 10 years prior, and now this veteran is going to owe us all this money. So we argued not only is that completely illegal, you can't do that under the statute, but also where's this evidence that the VA relied on to say that he was working now and making a substantially gainful income? The board can't just say, we believe the regional office that that's what this evidence said at one point. Like the board has to actually review that evidence and make its own decision about whether it shows what the regional office said. And since that evidence no longer exists, the board was wrong to just take the regional office's word and terminate this guy's TDIU. So we made this argument in an informal memorandum and conference prior to the briefing, that the VA attorney reviewed and automatically, immediately agreed with us that this was a terrible decision, that the board should never have done this, and that this veteran was entitled to restoration of his TDIU benefits, and so his 100% rating, effective back in 1997. So not only does he no longer owe the VA any money, but they also have to pay him for everything they withheld starting in 2006 when they stopped paying him. So this was a really good outcome for this really deserving veteran. I'm only sorry that it took 13 years to resolve this, 14 years to resolve this. But I am grateful that he kept the fight going, so that we were ultimately able to get involved and put this veteran back in the position that he should have been all along. So more CCK case win summaries can be found on our website. Thanks so much for tuning in. Be sure to check out our other videos and follow us on social media.